and we will get started. So it is recording, and welcome to the Seoul District Business Association Business Basics series. This is an ongoing business navigation and education series designed to help small business owners with the challenges of operating successful and profitable businesses. Today's Business Basics series is hosted by the Seoul District Business Association and sponsored by Littler Mendelson PC, the largest global law firm exclusively devoted to representing management in the full spectrum of employment, employee benefits, and labor law matters. These events are produced in collaboration with Flossin Media, a firm who specializes in marketing to and for multicultural demographics. I am Stephen Christian, and I'll be your moderator for this session. And today's presentation will last approximately 60 minutes with time for public comments and discussions. Also, feel free to add your questions to the chat, and we'll try to address those in a timely manner. And I think for this one, it's going to be more conversational. And so if there's something in the chat, feel free to turn on your mic and ask the question, because it makes for a more meaningful learning experience and dialogue. Today's topic is I'm sick. Leaves of absence and reasonable accommodations in the time of COVID. When employees call in sick to work, they can trigger a number of legal obligations for employers under state and federal laws, including the Oregon Sick Time Law, the Oregon Family Leave Act, the Federal Family and Medical Leave Act, and the Americans with Disabilities Act. The onset of the COVID pandemic has only complicated matters. Our expert presenter today is Megan Crowhust. Megan is a shareholder at Littler Mendelson and has represented corporate clients of all sizes, from multinational corporations to family-owned businesses. She provides practice, advice, and training to employers on various employee-related issues, including FMLA and ADA compliance, effective discipline and discharge, conducting harassment and workplace investigations, reviewing employment contracts, and policy and handbook development and administration. Megan will lead today's interactive presentation, which includes how to respond to requests for time off related to serious health conditions, school closures, and vaccinations, and best practices for engaging in the interactive process in response to requests for reasonable accommodations. And so do me the honor and great privilege of welcoming Megan, and feel free to take the reins.
Thank you, Stephen. I really appreciate that. So I'm here today in part because I have a specialized practice in this in the employment law world in working with businesses to accommodate employees in their requests for leave and time off, or other accommodations that are required in the workplace associated with a potential disability. So as Stephen mentioned in the introduction, the onset of COVID has really complicated that for many people. And in fact, in Oregon, many of the legislature has changed many of the laws associated with employees needing time off due to the pandemic. And it doesn't appear as though those changes to the laws are going to sunset at all. It looks like the legislature is intending those to be permanent, and therefore will be more and more discussion about how this is going to impact the future. So my hope for this presentation was that I would get a sense for those of you on the call, your business and how many employees you have, because one of the things I'm going to talk about is the size of your business will impact the nature of the laws that go into effect and whether you are responsible for complying. So I'm hoping that our participants who are off camera and muted might be willing to introduce themselves and what their business is, which is also a great opportunity for you all to network and to meet each other. So great. I see I don't know your name because it doesn't come up, but why don't you take yourself off mute?
Take yourself off mute.
Great.
Hi, my name is John L. Cleveland, and I'm the owner of Nietzsche Hydrate Electrolyte Water based in Portland, Oregon.
Excellent. How many employees do you have?
How many employees do you have?
2.
Great.
Great.
And where are you located?
I'm located in Portland, Oregon.
Oh, you did say that. Okay,
Oh,
great.
you did say that. Okay, great.
Okay.
Yes.
So I'm gonna have you mute just now because there's some feedback. Great. And then Ernest or Jacqueline, would either one of you be willing to share with us your business and how many employees you have?
My name is Ernest Harris. I have 60 employees. I do facilities management. COVID has taken a big toll on our business, and I have 5 people out with COVID right now. And so everybody around them has to be tested. So, and a lot of people call in sick, and I always have to cover those jobs. And I have a big issue in how to do that sometimes, because often the employees are not available to cover. So I'd like to hear some feedback on how I can address that.
Yeah, no, that's excellent. Excellent. Did you say you had 60 employees?
That's correct.
And are they all 60? Are they in Portland?
We're in Vancouver. So the business
okay.
stretches. So all my accounts stretch from Vancouver to Washougal and Washington.
Got it.
So yeah. So it's, the accounts are spread out.
Got it. Okay, great. I'm happy to help you work through that. And Jacqueline, did you want to share your business and how many employees you have?
Jacqueline, you're on mute. If you're trying to talk, we can't hear you.
So I will move on, and then if Jacqueline wants to share, she can share later.
Okay, and then we had
Marquise is also here.
Oh yeah.
Yeah, my name is Marquise Miller.
Excellent.
I don't have any employees yet. I just started my company on December 14th of 2020. I'm a clothing designer from Portland, Oregon. I make clothes and accessories, and that's pretty much it.
Congratulations.
Thank you.
So great. Okay, so what I will just start with here is my overview for today. So I'm going to talk about Oregon sick time, which is going to apply to any business that has really one or more employees. And then we'll talk about injured workers, the victims of domestic violence, harassment, stalking, sexual assault, the ADA and the Oregon equivalent, and for Ernest, there's also a Washington state equivalent. And then I'll talk about very briefly about the Oregon Family Leave Act and the Family and Medical Leave Act. And I hope that anyone on this call, if you have any questions, again, this is meant to be really an interactive process. And so if you have questions, don't hesitate to take yourself off mute and chime in, or put a message in the chat and Stephen will read it and we can go from there. But what I did to prepare for today and to help you all on the call is, as I introduced at the beginning, the number of employees a business has will trigger the obligations for employers in terms of handling requests for sick leave, particularly with COVID, and also reasonable accommodation requirements. So as you can see from this chart, there are a number of implications for businesses that are as small as 1 or more employees. So if you have 1 employee, you will be required to implement the Oregon sick time law. For employees with 1 to 5 employees, you are obligated to provide up to 40 hours of time off, but that time off can be unpaid. If you have 6 or more employees in Portland, you will have to provide paid time off. And if you have 10 or more employees outside of Portland operating within Oregon, you will need to offer paid sick time to them under the Oregon statute. So in addition to paid sick time, employers need to provide time off for what we call safety leave accommodation for victims of domestic violence. In addition, here in Oregon, if you have any veterans, you have an obligation to offer them Veterans Day off, also time off for jury duty, volunteer firefighters, and search and rescue. And then a little bit later, I'm going to talk about the need to offer reasonable accommodation for mothers who are breastfeeding, for time off and breaks in the workplace associated with that. And that also applies really to any employer who has 1 or more employees. However, there are exceptions for employers who have less than 10 employees. If you have 6 or more employees, this is where you get to a trigger for offering a reasonable accommodation for a disability. And I'm going to talk about that a little bit later, what those requirements are. But so that number is 6 or more employees. And then also, if you have 6 or more, you'll be obligated to offer leave and reemployment rights for any worker you have who's injured on the job and incurs workers' compensation benefits. So then, as I said, if you have 10 or more employees under Oregon law, you're required to offer paid sick time. And also there's no exception for the lactation accommodation. If you have 25 or more employees in Oregon, you'll be required to offer family leave and Oregon military family leave. And if you have 50 or more employees, you're now trigger the Federal Family and Medical Leave Act. And Ernest, for you, that's also going to trigger obligations under Washington state law. So next I'm going to talk about the leave entitlements. So now you know how many employees you need to have in order to trigger these requirements. We'll talk about leave entitlement. So for most of the businesses, both on this call and watching this video, you're going to trigger, if you have employees who work in Oregon, you're going to trigger the Oregon sick time law. So you will be required to offer up to 40 hours a year accrued at 1 hour for every 30 hours worked, plus 40 hours of carryover from the prior year. You also, again, if you have any employee who is injured on the job, and we'll talk a little bit about that, and it triggers the Oregon workers' compensation law, you'll have up to 3 years of time off plus reemployment rights. Under the Oregon state law and the federal law, if you have 6 or more employees, you'll be required to offer reasonable accommodation for a disability or a reasonable safety accommodation for someone who is a victim of domestic violence. We also have bereavement leave. So bereavement leave allows an employee to take up to 2 weeks for each family member's death. And again, with the impact of COVID, in addition to employees who are impacted by COVID, we also have employees impacted with bereavement leave. Then we have the Oregon Military Family Leave Act, which allows 14 days time off per deployment for anyone who has a family member who is entering the military. And then again, we have Oregon Family Leave, which allows up to 12 weeks for a qualifying reason. So Oregon Family Leave is triggered if you have 25 employees in Oregon. And so I won't be focusing very much on that today, under the assumption that most of the employees, most of the participants on this call have less than 25 employees. But Ernest, I appreciate that you have a larger business. And so we'll certainly touch on that, as well as the Family and Medical Leave Act. So there's also different requirements under the laws as to who is eligible to take this kind of leave. So for Oregon sick time, which again applies to all employers, your employees begin to accrue time off on the day they are hired. So upon hire, for every 30 hours worked, they accrue 1 hour of time off for any sick time reason. However, you can require that the employee wait until their 91st day to use any of the time that they have accrued during that period. So after the 91st day, employees can begin to use any sick time that they've accrued. And again, if you have 1 to 6 employees, that time off, it's called protected leave. In other words, you can't take any, you have to allow them to take the time that they have accrued, and you can't retaliate against an employee for taking that amount of time. And so after, if any employer has 6 or more employees, that becomes paid time off. It is up to 40 hours per year. And employees can, if an employee, let's say in a year, doesn't use any of their time off, they can carry over up to 40 hours into the next leave year. When it comes to the other criteria, all employees upon hire have rights under the Oregon Workers' Compensation Law, under the state disability accommodation statute, under domestic violence statute, and entitlement for bereavement leave. However, when you get into Oregon family leave, so if you have 25 or more employees, so under Oregon family leave, employees become eligible after they've worked for 180 calendar days, so approximately 6 months, plus they have to have worked for 25 hours a week. This is significant because most employers are familiar with the requirements under the Federal Family and Medical Leave Act, for which eligibility accrues after 1 year of employment. However, in Oregon, if you have employees in Oregon, or if you have 25 or more employees in Oregon, their leave entitlement is triggered after 6 months. So it's something to think about. So what are the reasons why people can use leave? And this, for you all, these are all some legal terminology, but and so there's some legal significance to these definitions, but it's good to talk about. And should anybody have any questions, as real practical situations come into play, we can talk about that too. But so for Oregon sick time, it's really almost anything. So there's diagnosis, care, or treatment of any illness or injury of the employee or a covered family member. So this Oregon sick time is intended to allow people to call in sick. They don't have to go to the doctor for that. They don't have to have any serious illness in order to qualify for Oregon sick time. This is purely intended for the employee who either has a cold or flu or some other reason for calling in sick. It also covers any reason that's permitted under the Oregon Family Leave Act, which I'll cover in a minute, as well as, again, domestic violence and a public health emergency. And again, this year, we really changed things, because up until this past year, I almost never saw an inquiry about what constitutes a public health emergency. And of course, COVID changed that, as well as the wildfires that we had last summer. I received some calls about that and whether that constitutes a public health emergency, particularly for small businesses, wondering if they needed to close down their operations for that. For injured workers, the injured worker statute defines an injured worker as anyone who has a compensable injury arising out of or in the course of employment that requires medical services or that results in a disability. And a medical service, again, for the injured worker statute, could be as minimal as going to get checked out in order to be confirmed to be released to return to work. Under Oregon law and the Americans with Disabilities Act, anyone who has a physical or mental condition that substantially limits a major life activity. That is a very low threshold. And at this point, most employees who we generally can see that where an employee presents a disability or a condition that limits their ability to perform work, it's almost universally considered a disability. So things that most people don't think of, things like migraines, things like stress, things like anxiety, These are all things that I see fairly routinely in my practice that create a lot of complications for employers in trying to evaluate how do we accommodate and respond to people who have said they can't work today because of stress and a stress-related condition. Again, for domestic violence victims qualify for time off work, bereavement, to grieve the death, attend the funeral, or to make arrangements for a death. And then within the Oregon Family Leave Act, the things most people are familiar with, pregnancy or parental leave, sick child or school closure. Again, this is something that we didn't see a lot of up until this past year. How do you deal with employees who themselves don't have any sort of ailment, but are asking for time off work because their children's school has closed, bereavement leave, and military deployment, which we've also talked about. So what kind of,
There are some
yeah,
questions in the
absolutely. I'd
chat.
love to answer some questions, Stephen.
Yeah, so the first one from Ernest was, how does this affect part-time employees who are employed for 90 days or more?
Yes, so under the Oregon sick time law, even part-time employees accrue protected sick time. So during that first 90 days, an employee will still accrue 1 hour of leave for every 30 hours worked. So after their 91st day, I'm not sure what the math is on that, but they likely would have some time that they would have accrued, just not at the same rate that a full-time employee would have accrued.
Okay, and then Jacqueline asks, what if there are 3 or more days? What if they're out 3 or more days? Are they required to have a medical excuse from a doctor?
It's an excellent question, and the answer is yes. And I'm going to cover that in my next slide on medical certifications. Do we have any other questions, Stephen, before I move on?
That looks like that's it, just those 2.
Great. So the next thing to think about is how much notice does an employee have to give you? So under the Oregon sick time law, the definition and the qualification is usual and customary notice and procedural requirements for an absence. So what does that mean? It generally means that if you have a policy, a written policy, you can prescribe in the written policy what sort of notice you require for an employee to call off work. But oftentimes, this type of notice might not be feasible. For example, most employers have some requirement that the employee call off work 1 hour or 2 hours ahead of their shift to allow the employer to replace that individual. However, there are times when an employee may not be able to give that notice. For example, if someone is hospitalized and they have been admitted into the hospital or they're sitting in the ER, they may not be able to call in before their shift starts. And there's some allowance within the law that if that is the circumstance, that the employer has to have some consideration for the fact that the employee was unable to contact their employer to call off for that shift. When it comes to sick child leave, there's a similar allowance within the law. Obviously, if someone is calling in and their child is sick, you would expect them to call in before their shift starts. However, as I said, if they're in the ER or there's some extenuating circumstance, then the employer can require that they provide notice within 24 hours of their day off. So in other words, if someone doesn't show up for work and you are trying to figure out whether that person's absence is considered protected under the law, or whether you can give them an attendance point for that absence, you can require that within 24 hours, they let you know whether that absence should be deemed a protected sick time reason for which they may be entitled to be paid if you have 6 or more employees and they have accrued time available, or whether you can administer an attendance point for them. One of the key things to think about is when it comes to Oregon sick time, protected time, and for anyone who has 25 or more employees, or for those of you who are hoping to have 25 or more employees, it is very important that when an employee calls in and they have time that they can take under Oregon sick time or Oregon family leave, that they do not incur an attendance point for those absences. And I think one of the things I see the most frequently in terms of mistakes that happen is allowing someone to take a paid day, but it also giving them an attendance point for not showing up for work on that day or not providing sufficient notice. So it's very important that employers are tracking how much time an employee is entitled to under Oregon sick time. For most of you, depending on how you issue paychecks, I'm not sure for many of your small businesses if you are issuing paychecks through a payroll company. If you are, the payroll company can track an employee's eligibility for sick time. If you're not using a payroll company, you will need to track how much time an employee has accrued and how much they have used, so that if there's ever a question about whether an employee who has a poor attendance record has used their protected time off, you will have to show that by having tracked how much time they've earned and how much time they've used. So when it comes to, and I guess to answer Jacqueline's question, for a sick child or even for an individual, there is no requirement to present a doctor's note until after an employee has been out for 3 days or more. And the reason for that is because not every ailment, not every calling in sick is going to require an employee to go to the doctor or to take their child to the doctor. In fact, when it comes to sick child leave, the Oregon legislature has considered that a parent is in the best position to determine whether or not this child's illness requires going to the doctor or if it merely requires them staying home from school. And then we get into sick child leave, as we covered, and I'll cover in a little bit more detail later. For bereavement leave, there's no notice requirement. And again, that's because if you think about it, if an employee loses their parent, they may not have advance notice of that prior to contacting their employer. For a military deployment, notice is required within 5 days of receiving the notice of call to duty. And similarly for when you get into OFLA and Federal Family and Medical Leave Act, there's an expectation that you provide 30 days notice if the leave is foreseeable. For example, for a pregnancy, for parental leave, or for a surgery. But if 30 days, if it's not foreseeable, the standard is as soon as practicable, which is typically either the same day or within the next business day. Stephen, do we have other questions?
Nope,
Okay,
we're all good.
great. And so to go along with Jacqueline's question in terms of what sort of medical certification can you require? So under the Oregon sick time, you can require written verification if the absence is more than 3 calendar days, or if there's a pattern of abuse. For example, if an employee is calling off every Friday, calling in sick, or if an employee is scheduled to work weekends and they call in, every Saturday or every Sunday, that can trigger a requirement that you can impose on the employee to provide a certification to support why they've been calling in sick every Friday or every Saturday. For injured workers, that's typically your OSHA Form 300 or a workers' compensation form needed to complete regarding the nature of the injury. And under Oregon and federal law and Washington law as well, for an employee who is requesting either time off or an accommodation due to a disability, you can require a fitness for duty form regarding their limitations that they submit to a doctor. So it's really a different thing calling off work. And if an employee says they need an accommodation, which may mean a reduced schedule or an adjusted schedule or some other form of leave or accommodation for a disability, you can require that the employee provide you with a fitness for duty certification that will assist you in determining whether or not their request for leave is reasonable. Again, under Oregon Family Leave and the Family and Medical Leave, there are forms that are provided on Oregon's Bureau of Labor and Industry website that the employee is required to take to their doctor to provide the information for the employer to know how long the employee is requesting time off work. There's also, I've also provided this chart for medical certifications within the certain criteria for Oregon Family Leave and for Oregon sick time. So note that for parental leave, in other words, if you have someone who's having a baby, there's no requirement to provide medical documentation for parental leave, either because you have a pregnant worker or because presumably your manager or you know this employee well enough to know that in fact they are having a baby or adopting a child or fostering a child. For sick time, for a child who's sick, as I said, there's no requirement for a medical verification until after their 3rd day off work due to the child being out sick. The sick child leave for a school or a child care closure, this came up this year. This is a brand new regulation that essentially that was imposed in part because of COVID and because so many employees were taking time off. The employer can require a verification of the name of the child, the name of the school or child care provider, and a statement that no other family member is able to care for the child. But note that that verification can come from the employee themselves. For bereavement leave, no medical verification requirement. In other words, you essentially have to take your employee's word for it, that whomever they have said in their family has passed away, that in fact, you trust that that employee has provided you with the truth. For domestic violence, you can request certain certification like court records. If they need to go into court for a restraining order that has a date on it, you can request records from a therapist or group therapy if that's what's happening. And domestic violence leave also protects employees who need to move, for example, out of their circumstances. And so you can request certification that supports their reason for the need to move. And then also for a military deployment, a photocopy of the service orders. So again, getting to Oregon sick time specifically, and I focus this program primarily on that because I understand that most of the businesses are going to be small businesses. And so there's some need to better understand what qualifies for Oregon sick time. So
before
yes.
There's a question on from Ernest.
Yes.
How much time is required for an employee to call in prior to their shift, indicating they cannot come in that day?
And so if I understand that's to say, like if they need to leave early, again, I think this is going to be incumbent upon the employer's regular practice. So
that's not what I meant. That's not what I meant. What I was asking was, if a person's shift starts at 3 o'clock and then they call at 15 minutes before it's time for their shift to say they can't come in that day, is there a requirement for that? For how much time is appropriate?
Yeah, unfortunately, I think under Oregon sick time, so for the first 40 hours of sick time, an employee, they have to comply with your regular policies. So in other words, if you have a policy in place that says the employee must call within 2 hours and they call within 15 minutes of their shift start, you may be able to implement some form of attendance discipline for not complying with the notice requirement.
That's what I thought.
Yeah. However, if the employee has a valid reason for why they couldn't call you until the 15 minutes before their shift start, you know, they may be able to get around that practical rule. So in other words, I hear this pretty frequently. I was in the hospital tends to be the biggest one, or for whatever reason, I have a reason why I couldn't call. I think if it happens one time, then you probably not enforcing your attendance policy. But if it becomes a pattern, for example, this is the third time they've called in sick within 15 minutes, then you may want to consider imposing your regular attendance disciplinary policy. Once it goes beyond in Oregon, at least, and Ernest, I'm happy to talk to you separately about, the implications for you because you have a larger business and because much of your business, if not all of your business, is in Washington. We can talk about that too. But once you go beyond the original 40 hours under Oregon sick, you can, in Oregon, apply your regular attendance discipline if an employee has incurred more than 40 hours of sick time. So in terms of these, the qualifying reasons, we have diagnosis, care, or treatment of a mental or physical illness or injury. This includes pregnancy and really any reason why someone needs to call in sick. We have parental leave, which we talked about, sick child leave, bereavement leave, domestic violence, public health emergency, and military deployment, all of which we've covered really. So for sick child leave, it's care for a child who is suffering from any illness, injury, or condition that requires home care. This includes ear infections, flu, it includes lice. It really isn't intended to include routine medical visits because the idea is you should be able to schedule around those. And it should cover any child who's 18 years or old anyone under 18 years old or an adult dependent child with a disability. As I talked about this year, many employers have had to make accommodations or to offer sick time for employees who have school closure and are required to work from home. So we want to be mindful that that qualifies, and also know that included in school closure in Oregon is anyone who has someone who provides care for their child, whether or not that's paid and whether or not that's a family member. In other words, one of the things that I saw come up oftentimes this year is my mother is my child's primary care provider. She does not want to watch my child because of the impact of COVID, and I now need to find other daycare providers. So I need to take time off to find that. That kind of leave is covered under Oregon sick time. So for bereavement leave, know that employees need to take that within 60 days of notice of the death of the family member. It can be used to grieve, attend a funeral, or make arrangements related to the death. For domestic violence, we'll go through that. People can take time off to seek legal or law enforcement assistance, to seek medical treatment to recover from injuries, to obtain counseling, to obtain services from a victim services provider, or to relocate or to take steps to secure an existing home. As I covered also, the public health emergency covers COVID-19 and wildfires. Historically, it's never covered snow, and that's largely because there's generally not a public health announcement related to a snowstorm. So historically, we've always been able to exclude someone who can't come to work because of snow conditions from protected time off. Or whether a public health authority has determined that the employee cannot work. And so again, this came up during COVID this year. Excuse me. The other one we see pretty infrequently is taking time to spend with a spouse or same-sex domestic partner who is called to active duty. So we previously talked about notice and certification. I'm going to move through these pretty quickly so that we can cover some of our practical implications. But know that healthcare providers are not limited to just doctors. essentially any healthcare provider who is recognized by an employee benefits plan, a nurse practitioner, midwives, clinical social workers, or a therapist. All of these individuals can qualify as a healthcare provider. So you want to be careful about telling an employee that the note that they might have provided doesn't qualify because it's not signed by a doctor. Also know that anytime you get a doctor's note or anything related to an employee's health, that should not go into a personnel file. It should be maintained in a separate medical record. It used to be that that employers I knew, they would keep a red file perhaps and put the employee's health record into a red file that went within the personnel file or stayed outside of it. These days, most businesses I know and employers I know are keeping their records electronically, so they don't actually keep a file folder. So you want to make sure that you keep a separate file for an employee's doctor's notes and things like that. And that's largely because employees have a right to ask for their personnel file or their personnel records, and that those should and that in doing that, you want to ensure that there are protections around disclosing an employee's doctor's notes and medical records. And so by keeping them separate, you can have that safeguard in place. And in particular, to prevent an employee's supervisor, excuse me, from inadvertently or another employee from being able to inadvertently review and view doctor's notes or medical information for your employees. So make sure that paperwork is accessible only on a need-to-know basis. If you have an employee who's been out of work and needs to return to work, you can require that they provide a fitness for duty certification. And when you do that, you'll want to make sure that you include a job description if you have one. If you don't have a pre-printed job description, you may want to make sure that you include a description of their duties when you provide the employee with a fitness for duty certification. I also have templates for these, and I'm happy to share these with anybody on this call or anybody who views this program and wants to reach out to me separately. I'm happy to provide a template for you to do that that will be compliant with both Oregon and federal law. Know that employees may ask for intermittent or reduced schedule time off, and I'm going to cover that next when I cover reasonable accommodations. So really, you just need to be aware of when an employee asks for and is absent, what the reason or the excuse for the absence is, because that's going to be your trigger to understanding whether it's protected under the law as protected time off versus the kind of time that you can incur an attendance point for. You want to make sure you're not discouraging people from taking time off if they need it, particularly, for example, in COVID, there was a lot of question about whether or not the employers could require employees to come in if the employee didn't have a confirmation that they had a positive COVID test. But the implication for what that could mean for the workplace, if you're requiring employees to come into work, could you be exposing employees? So the other thing I wanted to make sure that I covered today is the Americans with Disabilities Act, or the equivalent under Oregon and Washington state and federal law, because one thing to know is that under the FMLA and Oregon Family Leave and Oregon Sick Time, as we've been covering, the law requires that the employers allow a certain amount of time off work for an employee who is sick or needs to recover from an ailment. But the ADA, or the disability laws, have an inverse obligation, which is that an employer needs to allow an employee to work if they can work, if the employer may need to provide an accommodation that would allow the employee to come to work every day. One of the common mistakes that I see from employers is requiring an employee to stay home. So for employees who have a disability and they want to work because they need the money, because presumably anybody who is working is doing it to earn money so they can care for their family and for themselves. So if an employee wants to come into work and they tell you that they have a health condition or a medical condition that may require them to have some form of accommodation, it has a different trigger. You can't require them to stay home. For example, what I've seen sometimes is an employer say, I think you would do better off if you stayed home to recover. So we're not going to let you come back to work until a certain time period when we think it would be safe. You really have to rely on that employee's doctor and their doctor certification and what the doctor says before you make that kind of an assessment. So the kinds of things that employees, that we call it the interactive process. And if an employee gives you notice that they require some sort of modification to their job to come back to work, you now have an obligation to engage in what we call the interactive process. Now, again, I just want to remind everyone that at least in Oregon, the obligation to offer an accommodation for an employee who has any form of disability is if you have 6 or more employees. That's a pretty low threshold for many employers who are kind of trying to navigate how are they going to provide an accommodation for an employer, for a business with only 6 to 10 employees. The kinds of things that you need to think about that come forward in terms of imposing on an employer, a manager, to talk to the employee about what kind of accommodation they may need, sometimes comes very directly. And the employee will come forward and say, hey, I can't do this part of my job because I have a shoulder injury or, for whatever reason. They may ask you for something specific. I need a stool at the cash register. That's a fairly common one that I've seen. A request to work part-time can be considered an accommodation. A request to work from home is an accommodation. Sometimes it's not as direct as the employee coming to the manager. Sometimes it comes in the form of a doctor's note. So if you've received a doctor's note from your employee that says there's some sort of restriction, they can only work up to 30 hours per week, for example, that doctor's note itself is a trigger for the employer to start to have a conversation with their employee about what sort of accommodation they may need. Other things that are less obvious that employers, managers, and supervisors, business owners need to think about are if someone is consistently late to work and you impose some sort of attendance discipline for being tardy or late, and they say, I have a problem because my medication makes me tired or groggy and I can't come to work in the morning. Even that can be a trigger for what do we need to do to make sure you're getting here on time, and what your shift will look like. Similarly, if an employee is consistently absent or taking time off, or if that has changed, one of the things I saw occur within the law is this change that happened from you used to be able to impose attendance discipline anytime an employee was absent. But if somebody has a consistently good attendance record, and now all of a sudden they're not coming into work, that in itself may impose an obligation for you to sit down with that employee and say, what's going on? You used to have good attendance. Is there something happening that that might require us to be offering you some sort of accommodation for that? Same thing with a limitation due to an accident or a surgery. This is true even if the accident occurs outside the workplace. For example, a car accident, I've often seen become a trigger for the employer to have a conversation about whether an accommodation is required. Same with performance issues related to known or obvious physical or mental conditions, or reliable information from a coworker or a family member. So in other words, if the employee hasn't come to you directly, but either their family member or a coworker has confided in you that this employee is having difficulty due to any form of medical condition, that may impose an obligation on you to call in the employee and ask if they are having any difficulty or need any accommodations at work. Now, keep in mind, when you're a small employer, your obligation is only to provide an accommodation that is reasonable. And so if this employee is asking, for example, to take every Friday off work, and you only have 5 employees, and this employee is regularly scheduled to work on Friday, you may not be able to accommodate that. On the other hand, if there is a way for that employee to work Sunday through Thursday and a different employee to cover Friday through Wednesday of the following week, that may be an accommodation you're required to make. It's all based on the business, and it's all based on what is feasible and what is not, and what the employee is seeking. So here are some examples of things that are reasonable: requiring additional time off work, whether that's to attend doctor's appointments or to recover from an illness, potentially restructuring the nature of the job the employee does, allowing them to work from home if that's feasible, offering a reduced schedule, in other words, working 30 hours instead of 40, and potentially assigning that person to a vacant position that they can handle, and maybe even unpredictable attendance. For a small business, that's unlikely to be a reasonable accommodation, but there are some circumstances for large employers where that may be required if, in fact, the employee doesn't have to work a 9-to-5 type regular interfacing job. Things that are not reasonable are indefinite leave. If someone doesn't know when they're going to come back to work, you don't need to hold that job open for that long. You don't have to create a new job. You don't have to remove key functions from the employee's work. You don't have to reassign them to a new supervisor. So as at the top of the call, we were going to talk about COVID and vaccines. So I just wanted to cover pretty quickly. You can ask an employee if they have tested positive or if they've been in contact with anyone who's tested positive for COVID. One thing I should preface is that there is a tension with employers with not wanting to ask too much information or not wanting to get too much medical information versus not asking for enough or understanding what's going on with an employee. It used to be that we would advise employers, you shouldn't ask an employee about their health, not to be nosy, what you don't know, not to probe into someone's privacy. However, as the law has evolved, we've really kind of encouraged employers to engage in conversations because there is some obligation within the law now that if you have any reason to know that an employee is having difficulty performing their job because of a medical impairment, that the employer needs to be engaging in a conversation with their employee about that. When it came to COVID and the influx of COVID, the EEOC issued new guidance related to this because what the EEOC determined is that the impact of the health and welfare of the nation as a whole allowed for employers to go to probe a little bit further into an employee's health. So that is why it's now, with COVID in particular, acceptable to ask an employee if they've had a test or if they've tested positive for COVID or been in contact with someone who's tested positive. You can also ask your employee before they return to work or upon when they report to work whether they have experienced any of the COVID symptoms. You can require a temperature check. You can administer a COVID-19 test. You can send employees home if they have, if they are exhibiting symptoms of COVID, and you can require a doctor's note before you return them to work. So you can bar your employee from the work site if they refuse to answer questions or have their temperature taken. You can inquire about travel within the CDC guidelines. all COVID information is considered medical information. So you have to be very careful when you communicate to your other workers. You can communicate that someone in the workplace has had COVID or has COVID, but you don't want to identify who that person is. So one of the questions that I had for people are whether they're requiring a vaccine to return to work. An employer may require vaccines and may require proof of the vaccine. However, the employer also needs to know that there are reasons for why an employee may not be able to get a vaccine due to a prior medical condition. So for example, or for a religious reason. So although you can require vaccines, you also have to allow for some variable if the reason why an employee has not gotten a vaccine is related to some health condition that precludes it or for a religious reason. If you do require employees to have a vaccine to come to work, you may be, of course, I think one of the great things is you don't have to require employees, you don't have to pay for it since they are offering vaccines for all Americans for free. However, you may need to pay them for the time they need to take off work to get one. There's some question about that. And so it's something to think about. So this is about an hour into the program. I had a number of practical scenarios that I was going to cover. And so maybe people can kind of chime in to Stephen in the chat on whether you want me to go through some of these practical scenarios, or we could do a Q&A. Or at this point, since we've gone on for about an hour, we could close out the program if people have other things they have next. Stephen, do you want to monitor the chat and see what people think?
Yeah. So I'll be monitoring the chat. Looks like nobody has responded yet.
Well, since people are still on, I will assume that means they're still interested in hearing a little bit more about some of the practical scenarios that I've given. And I'll use this as an opportunity to let anybody know if you, because it's after 11, if you want to drop off, I will just keep going with the practical scenarios until nobody is on but the moderator and myself. Great. Okay, so this first scenario is Oregon sick time. So Minnie calls off 30 minutes before her shift because her daughter Maya has a cold. And we covered this a little bit, but the question is, do you need to give her the time off work? Well, the question will be, how long has she worked for the company? Has she been there for at least 90 days? The second question is, has she already used 40 hours of sick time? If she's already used the 40 hours she's accrued, there's no other obligation within Oregon to allow her additional time off work unless you have more than 25 employees, in which case she still wouldn't qualify because a cold does not qualify for Oregon family leave. It's not serious enough to allow additional time off. Do you need to pay her for the day? That will depend on whether you have 6 or more employees working in Portland or 10 or more employees in Oregon. If you do, then you will likely need to pay her if she has accrued paid sick time. What if this is the 4th Friday in a row this employee has called off and called because their child is sick? This is not that uncommon. I've seen this question come up before. And I think in that circumstance, then you can inform the employee that they'll need to provide a doctor's note to support that need for leave. That's for 2 reasons. First of all, they've already had, this is their 3rd time they've called in for a sick child, and because they've shown a pattern of abuse. In other words, they're calling off every Friday. What if Maya has COVID? Would you then need to provide the time off work? I think, again, the answer is yes, under Oregon sick time. And as we covered before, what if Maya's daycare provider has COVID and that's the reason why Minnie can't come into work that day? As I said, COVID really required employers to have a lot more flexibility in how they are engaging with their employees in terms of understanding the reasons for the need for leave and understanding how that impact. The other thing that came up so frequently with this is, do you have to allow an employee to work from home? In other words, it's one thing to allow an employee to take the day off work. It's another thing to have to pay the employee because they're working from home. And that will depend on the nature of that employee's job, how they can do the work from home, and whether you can monitor that. So for example, one thing we saw come up quite a bit is an employee who says they're working from home, but they're not responding to any emails. They're not responding to their chats. That imposes another obligation where you can begin to engage, is this employee really working from home? Here's my next scenario for bereavement leave. So Janet's brother Michael passed away and she's seeking 2 weeks off to plan the funeral and to assist with the financial aspects of his death. So one of the questions is, do you have to give this employee 2 weeks off? Well, under Oregon family leave, you would, but Oregon family leave applies if you have 25 or more employees. And so if you have fewer than 25, then an employee is entitled to take bereavement leave under their Oregon sick time, but they're only entitled to up to 40 hours of time off under Oregon sick time. So this is going to require some evaluation of whether allowing them the additional time off after 1 week if they have a 40 hours of accrued sick time. Can your business support that? Do you have to accommodate that additional request? The other thing that has come up that I have seen at the end of bereavement leave is an employee saying, I'm too depressed to return to work. My husband passed away and I can't come back. I'm not ready. Again, that's really could be a request for a reasonable accommodation because depression can be a disability. And so these are, there are no hard and fast answers. The reasons why I'm bringing up these scenarios is to give you all a little bit of a flavor for the kinds of things that we're seeing and the kinds of things that my clients ask me about. I used this scenario for domestic violence. When someone needs to take time off to go to a court appearance, to enter a restraining order, that applies, and going to group therapy. One thing to keep in mind is I've certainly had this come up where someone needs to take, again, it's always Fridays off for group therapy. And you can ask the employee if Fridays would create a hardship, if there's any other time that they can go to the group therapy, or if they need the entire day off, or if they only need a half a day off to participate in that. Another scenario that comes up is needing time off for substance abuse treatment. Under both state and federal law, treatment for substance abuse is considered somebody who has substance abuse history, has a disability, and therefore you may need to give employees time off to attend substance abuse treatment. However, you don't need to give time off if someone who's told you that they're an alcoholic calls in and says they're hungover and they can't come into work. Treatment is required, but you don't need to give somebody time off or an accommodation if the reason for their absence is directly tied to that substance abuse issue. One of the things I do see come up is an excuse for yelling or unprofessional behavior due to a disability like bipolar disorder. You can continue to maintain your standards for conduct in place at your in your workplace. The other thing that we covered is the idea that high anxiety and stress, those are also considered to be disabilities within Oregon state and federal law. However, an employee does not need to or cannot be required to change their supervisor, for example, because this particular supervisor is too stressful. So I will skip my last scenario, just given the time constraints. But as I said, I'm happy to answer any questions at any time. I certainly wanted to provide my contact information. It is our goal at Littler to work with all of our business members of the Sole District Business Association. We are happy to provide a employee handbook or policies that apply. I considered offering a template policy, but the truth is the policy and handbooks will change for based on the size of the business. And so we would want to have a conversation with each business owner to help implement that, but we're happy to do that at no cost to our businesses. So please feel free to reach out either to someone at the Sole Business District Association who can put you in touch with myself, or using my email address that's available on the screen. Thank you.
Awesome. Thank you. Thank you. Thank you. And so again, thank you, Megan, for this valuable information. And we'll be sure to make sure to add your email address and all the contact information on the page when we post this and on YouTube. And for those that are watching, you know, if you want to listen to this presentation again or watch this presentation or any of the past episodes of the Sole District Business Association Business Basics Series, it'll be available on the Sole District Business Association website, which is www.soledistrictbiz.org, or on YouTube at Flossin Media TV. And so also, you know, just be sure to follow us and the Sole District Business Association on social media for any of the updates on many presentations like this and many more valuable opportunities to you know, connect with people in the community, as well as connecting with other professionals like Megan. And so if you have any other questions, comments, or concerns about the series or the presentation that we just saw, feel free to contact the Sole District Business Association at 503-841-5032. And so there will be another episode of this, another presentation in about 2 weeks. And so with that, you know, really appreciate your time, Megan. Appreciate all the people in the audience for sticking with us and engaging with this content and this material. Again, thank you to Flossin Media and the Sole District for hosting this. And yeah, enjoy the rest of the week until we connect in the next 2 weeks.
Great, thanks, Stephen.